During the first calling of the case on May 13, Justice Navindra Singh had said then that the facts of the matter were not in dispute and he went ahead to set timelines for the filing of submissions and replies with oral presentations set for September 12. But at an emergency hearing on Wednesday, Justice Singh explained that when he read the affidavit submitted by Roysdale Ford on behalf of Opposition Chief Whip Christopher Jones and trade unionist Norris Witter, he came across a serious allegation in paragraphs 32 and 42. The claim is that the legislation could not be considered to be lawfully passed because, among other things, the opposition members of Parliament were deprived of an opportunity to participate in the debate and subsequently the bill's passage. James and Witter claimed in their submissions to the court that the sitting of the National Assembly on December 29, 2021 was not conducted in accordance with the standing orders and to some extent the Constitution of Guyana. But Attorney General Anil Nandlal disagreed with this claim and proffered reasons similarly submitted by Clerk of the National Assembly Sherlock Isaacs and Speaker Manzoor Nadir that the opposition MPs chose not to participate in the debate and instead engage in a ruckus in the House. Nandlal argued that nothing prevented the opposition MPs from participating except their own actions.
We were happy if they were going to use the debates as the basis to express their obvious differences and their obvious opposition to the bill. They chose not to do that. And then now saying that they were denied the opportunity to debate and denied the opportunity of speaking. It's really a barefaced type of position.
But during the hearing, Ford told the court that although some opposition MPs were misbehaving, there were others who were slated to speak in the debate that did not leave their seats and were awaiting an opportunity to contribute to the debate. Nanda said there was recorded evidence submitted to the court which would prove that it was the parliamentary opposition that disrupted the sitting, but in any event he maintained that the bill was lawfully passed. Justice Singh said he intends to stick to the September hearing for oral presentations and said even if a trial is to be held, it will not delay the case, a case he considers to be of national importance. New timelines were set on Wednesday where Ford will go ahead and file an affidavit in reply to submissions made by June 13. After that, Justice Singh has asked that all parties sit together and draft a joint statement on agreeing facts and disputes which will be submitted to him by July 7, after which there will be a hearing on July 15 at 10 hours. It is at that hearing that the judge will decide whether a trial is needed or even a hearing for counsel to orally ventilate their points on the disputed facts. For the newsroom, Campbell.